Okay, good afternoon, everybody. Welcome to our episode 4, season 4 of our association leadership webinar series, Elections and Annual Meeting, Best Practices and Pitfalls. I want to welcome everybody this afternoon, and especially welcome Jeff Rembaum and Michael Bender from KBR Legal. Welcome back, guys. My name is Craig Vaughn. I'm the Chief Financial Officer, one of the founders of Castle, and I'll be a host of the meeting today, or webinar today, and take you through a series of questions that we're going to try and stump Jeff and Michael on. Virtually impossible, but we're going to try again today to get there. Guys, quick, Michael, maybe a quick word about KBR.
Sure. Good morning. Good afternoon, Craig. Again, thanks to you and your team, Marinez and Castle, for putting these on. Jeff and I are happy to be here with you. For those who may not be aware, K. Bender Rembaum, we are a community association law firm. That is where we focus. That's what we concentrate on. Website, kbrlegal.com. When you go there, you will see community association law. It won't be a drop-down one area of practice. It is our area of practice. We are 21 attorneys, 10 of whom are board certified in condominium plan unit development, including Jeff and I. We also have a board certified specialist in construction law. We assist all of our clients with all aspects of community association representation, from day-to-day operations to helping you update your covenants, enforce your covenants, assist you with contracts, collections, foreclosures, construction defect, and the like. Many of us are teachers of education. We do a lot of that for free, like we're doing with you today, Craig. Jeff is a prolific writer of Rembaum's Association Roundup, a lot of great articles. Our other partner, Robert Kay, does Legal Morsels, both of which are available at no charge on kbrlegal.com. And we are very active in legislation. As you all know, there's many of our attorneys are actively involved in both through the Florida Bar as well as through CAI's Florida Legislative Alliance. We do radio shows, on and on and on. So, Jeff, is there anything you want to add?
I think you did a fantastic job. Just that if you haven't had the pleasure of having Michael attend your annual meeting, don't be shy. He does a fantastic annual meeting.
Well, that's a new elevator speech. You guys probably worked on that all over the holidays. So
that was off the cuff.
Nice.
That was really good. That was your best introduction of our firm.
That was off the cuff, man.
I think today is going to be a good day.
And did I mention kbrlegal.com?
Interestingly, you did.
Okay.
So everyone, I want again to remind you that Jeff and Michael are here to not provide specific advice for your association, but to give their thoughts on the things we're going to tackle in the agenda. We are going to use polling again today. And Marinez, if we can you post poll question number 1, just check on who we have in the audience. And while you are filling that out, listeners, I'll just take us through the agenda of things we want to cover today. We have the annual meeting itself, how the annual meeting is conducted. We're going to talk about that. Elections, the organizational meetings. We're going to focus, organizational meeting, excuse me. We're going to focus in on best practices. And then if we have time at the end, we will answer some questions that are sent in. I have gone through all of the questions that you submitted with your registration and kind of incorporated those topics into our discussion today. So let's move on. And but before we get into the election, before we do that, let's see who's in our audience today. Marinez, can you post the results? Good. So up 200, again, about half and half, which is good. And there are some nuances in the election and annual meeting notice issue area between condos and HOAs that we'll address today. So before we jump into the formal agenda on elections, Michael, there was a special session of the legislature, started on Monday. Anything on the agenda that we should be concerned about?
Nothing that's been brought to my attention. This is a 12-day special session. Well, the only thing that I'm aware of with regard to the special session is it's impeding the ability of the House senators and representatives to hold their committee meetings and move forward on legislation that will start March 7th, which is our regular 60-day session in Florida here. The highlight that I'm aware of with this special session, I'm sure everybody's read the headlines, has to do with Disney and what they're going to do with that district. I don't know, Jeff, if you ever saw what the other items were on the list. I didn't.
Well, I did. I saw 2 other items, but interestingly, one of them was addressing our condominium legislation. but yet I have not seen anything other than that they were going to be discussing it during the special session. I've heard that there might be some traction in getting some legislation, but I don't know. We don't really have an idea yet which way it's going to go, whether it's going to be substantive or just glitch. Should be
Right.
interesting anyway.
Yeah, and on that, Craig, yeah, I didn't. I was basically completely out of touch yesterday, so I don't know because they just started this on Monday. But there is a glitch bill, quote unquote, being discussed, and for those who may not be aware of that term is exactly what it sounds like. They passed Senate Bill 4D. The three of us have had a couple of webinars with you guys on that regarding milestone inspection and the structural integrity reserves. And there's obviously been a lot of questions, clarifications that have been sought on some pieces of that legislation. And there is discussion about about addressing those glitches, like Jeff mentioned, housekeeping more than substantive, although they would impact certain substantive parts of the bill. I don't believe that's part of the special session to pass anything. It might be part of a discussion, but I don't believe the actual I have not seen a draft of that, and people I've spoken with have indicated that the draft isn't actually officially out yet. So there really isn't a lot to offer on that, but we do anticipate there being some talk on that. When we come back in April, obviously it'll be mid-session. We'll be in a much stronger position to give a state of the union, quote unquote, update on what's going on in Tallahassee.
Awesome. Well, the fun starts March 7th. I think that's when the legislative session starts. So we'll be following closely, those of us who are in the game. Okay, let's move on to the annual meetings. Let's get to the crux of our webinar today. And I think if we start slowly, Jeff, does an association have to have an annual meeting?
They do. Both the statute certainly suggests it in 72306 as to homeowner associations. The sentence couldn't be any clearer. The association shall hold a meeting of its members annually for the transaction of any and all proper business at a time, date, and place stated in or fixed in accordance with the bylaws. So there, absolutely, we're going to have that annual meeting. 718, it's not, the language is slightly different, but in a couple of places. In 718.112, for you statutory buffs out there, the annual meeting of the unit owners must be held at the location provided in the bylaws. So there we have some direct language, and also language further in that legislation. The bylaws must provide the method of calling meetings of unit owners, including annual meetings. So yes is the short answer, and now you have the long answer that goes with it.
Just to throw a wrench in the, or actually an off the cuff question, Jeff. Some association documents I know say you have to have your meeting January 9th or the third Wednesday, and they're very specific. Is there any flexibility, or is it the documents say this date, you go that date?
Legal answer is your bylaws say you need to have it on January 2nd, and I have one of those. You need to have it on January 2nd. They ran into a problem. I don't know if it was printing, whatever the issue was in getting the notices out. The meeting ended up being much later in January. Practically speaking, by the time somebody would complain about that, you would have already cured what ails you, because you would have already had the election take place. You should strive to do it on the date. If you don't want to do it on the date in the governing documents, well, then amend your governing documents.
Okay, good. Well, appreciate that. One more quick question for you. Meeting notice requirements for the annual meeting.
Meeting notice requirements. Well, for a condo, we have two meeting notices, right? We have the Super Bowl coming up. So 60, 40, 35, 14, hike. 60 days before the election, you're going to do the first notice. And I'm not going to go into the candidate information sheet, which would have been our 40 and 35. And we'll jump into the second notice at 14 days. The HOA really only has the one required notice, unless the bylaws provide otherwise, which is going to be that 14-day meeting notice prior to the annual meeting.
Yeah, so there are notices. I'm going to pull up a sample notice that we use, just so folks can have a look at it while we continue on this topic. The annual meeting, normally associated with an election. Michael, we've had some questions emailed in about, can you have other items on your annual meeting agenda?
Yes. I mean, I guess it would depend on what those, remember, it's a membership meeting. It's not a board meeting.
Mhm.
So the annual membership meeting agenda, again, one of the things we talk about when it has unfinished business and new business, at least I offer that those are typical terms: old business, new business, unfinished business, new business. To leave those there without indicating what they are, I think is a mistake. I think if there's unfinished business, it should be indicated what that unfinished business is. If there's new business, there should be, vote on proposed amendment, etc. Vote to approve, to authorize board to take a line of credit. Vote to on a material alteration. If there is a vote on less than fully funding reserves, those could be items that are listed on the agenda, and they should be subcategorized under new business. So yes.
Good. And then if you'll notice that our sample, we combined the meeting notice to include both the annual meeting and then the director's organizational meeting. We're going to talk about that a little later, but
that's how we do it, recommended too. Whenever we prepare these notice packages, we'll do the second notice immediately following the membership meeting that board will hold its organizational meeting. That is certainly the recommendation. And that right there, you've now noticed the board meeting timely.
Yeah. By the way, interestingly, we do not draft these notices. We actually have the attorney draft them in the format they want that are, of course, with the documents, and then we save them in that format so we can kind of use them over and over. But
yep.
we prefer if you call us every year.
Yeah, I know you do. Okay, that's kind of what. So this is a sample meeting notice. Let's go on. Jeff, we had some flexibility during the COVID pandemic with respect to emergency powers and holding meetings, but I guess, does the annual meeting have to be in person? That's the question.
I have that much later in our webinar this morning, but I'm happy to address it now. I think you're asking, can we have Zoom? Are you asking if we can have Zoom only meetings?
Yeah,
is that
they resume exactly.
Yeah. I do have one client that went out of its way and amended its bylaws to provide for Zoom only membership and board meetings. It hasn't been tested in the courts. We know you have the power if there's a true governor called state of emergency. But in any event, that they codified it within their governing documents. I think it would be hard to disturb that after the membership voted in favor, et cetera, and so forth. We suggest to our clients, you can still have your cake and eat it too. Notice the meeting to take place so that those without a computer, those without a phone can still go to a common room and listen in. Whether you have a computer or you have a speakerphone in that room, that is fine. And then you can still encourage attendance and still broadcast via Zoom. So you can do the hybrid meeting approach. And we really don't see a problem doing that, so long as you're looking out for the minority members who may not have access, right? They may be Zoom challenged or electronically challenged. You don't want to leave the argument. You don't want to leave your flanks exposed that I couldn't attend because I don't have a computer or I didn't know how to dial in. So yep. The manager should make available, the board should see to it that there's a common room available so that members can come in and listen and participate without having to do it from their own home.
Right. And I agree. And the only thing I'll add to that is if they don't have a common room or there is nothing that stops the management company having it a room, you have a room in your office. And that's where, because the manager is going to be there controlling the Zoom, so they can invite owners to this room in the office, the managers at the management company, and anyone else can jump in. So that's still a valid location, presuming it's within the proper distance of the condo, but I'm sure it is.
Miles, right? So here's a question, or not a question, but just something interesting. Strangest places the three of us have ever been to attend an annual meeting. I'll start us off. Shopping mall. Outside of a store in a shopping mall was the location for the annual meeting. They didn't have any other place. They got the store to agree, et cetera, and so forth. There were chairs set up. Firehouses, libraries. How about you, Mike? Anything good?
Nope.
No,
outside. I had nothing that, no, there's nothing unusual. I mean, it's been outside by the pool, community pool, but that's not unusual. The weather's nice. It's actually very comfortable.
Yeah.
I've been at a meeting on the portico, I guess it is, of a public school underneath the walkway. You couldn't get in the school, but they had it at the outside the school.
Love it.
Lots of fun.
So, but Jeff's point is, I couldn't agree more. Set it up. It's a very simple thing. And I like what you said, Jeff, don't expose your flanks. It's very simple, guys. Just to have an in-person location. No one may show up. The manager's going to be there anyway, controlling the Zoom, or if the manager's not and the board is controlling the Zoom, but it's just an easy solution.
Good. Okay. And then quick, another question on the meeting, Michael, who would normally chair the meeting?
I mean, the governing documents, may actually dictate that. Again, much like, we talked about, and I couldn't agree more with what Jeff said also about the meeting date. You follow your bylaws strictly if you can. We call it a quote technical violation if you have to have the meeting a week later. I mean, or whatever like that is. Same idea here. Who chairs the meeting? I will tell you in, gosh, almost 25 years of doing this. I can't think of a situation where there was a huge fight. Sometimes there's pushback, but you generally look to the bylaws. When I'm asked to come to meetings, typically the president or the manager will introduce me and say, Mike's here, he's going to run the meeting. And I mean, obviously it's a lot easier. People will have questions, they'll challenge things that are often, when it comes to annual meetings, legal issues. And so, one of the questions that was asked, is it standard for council to attend meeting? It's a business decision for the board. I mean, if you're having an election, I'd recommend it. Obviously, if there's no election, it doesn't seem as necessary. But if you're having an election, you want to make sure that there's that you have the ability to address questions regarding any illegal matters that come up with the process, with the votes, with the ballots, the whole thing. Yes, but so generally, who chairs the meeting? I don't know that. I don't know that there's a straight answer. I think when the attorney's there, the attorney is typically asked to do so, and I would step in and do that. Sometimes it's the president. But I will say, if the president isn't comfortable chairing the meeting, the president can open the meeting and then pass the chair.
Yeah. Okay. Interesting follow-up question to the location. Do you have to make sure you can accommodate all of the homeowners? So the example was 80 people normally come, but there's 700 people in the community. Do we have to be able to accommodate everybody?
The only thing I'm aware of, and I'll let Jeff jump in, but the only thing I'm aware of the statutes provide is in 720. 720 added language regarding the requirement to ensure that the location is handicap accessible. So that's the one thing when you have an in-person location for an HOA meeting, you need to make sure that is and quite frankly, I think any meeting you're doing should try to do that. But Jeff, I don't know if you have anything else to add.
Just to make sure that you create a fair playing field. If you were to have a homeowner association, 700 members in a room for, as you suggested, 70 people, and all 800 try to show up, and then they say, hey, we couldn't vote because we couldn't get in the room. That's going to be a huge problem for that association. So I think there are concerns you need to think about far in advance.
Excellent. Okay, we're at the annual meeting. We're looking for a quorum. Jeff, Condo Law 101, can you help everybody understand what a quorum is?
Sure. Quorum in its most simple terms is simply the necessary percentage of members in present or in person necessary to conduct the business of the association. That would be the most simple definition of a quorum.
In person or by proxy?
Yes. In person
or by proxy. So now how do we establish the quorum of a meeting?
Well, we're going to have two different ways to do that. One condo, one HOA. For HOAs, unless the bylaws provide otherwise, then provide less actually, unless the bylaws provide for a lesser percentage, it's 30% of the members. And for condos, unless the bylaws provide otherwise, it's going to be a majority. And again, not otherwise, but less. So it's going to be a majority of all the voting interests unless bylaws provide for a lesser number. So you always have to remember to look at the governing documents in case there is a lower number. And we've got some HOAs, and we'll talk about this later, that have completely abolished quorum requirements to have the election in the first place, similar to a condo, and we'll get into that, I'm sure.
Right. And then, Michael, there's no quorum. Does everybody go home like during the meeting? What's the deal?
That's going to depend on what we're talking about. In the condominium cooperative setup, there is the quorum requirement is only to establish that there's going to be a quote official annual meeting where you'll go through your agenda like we had listed earlier. But the statutes provide that if 20% of the eligible membership votes, then there will be an election regardless of whether there's a quorum. So if you have quorum requirements a majority, you have 100 homes, 100 units, majority is a quorum, you need 51 present in person or by proxy to hold an official meeting. Like say you were trying to actually vote on an amendment or something. But you'd only need 20 of the 100 to actually have submitted a valid ballot for you to move forward with the election. So no, you wouldn't go home if you had enough ballots for the condo. HOA, again, and something you'll hear Jeff and I repeat often, the HOA is unlike the condo, which is really a creature of statute, and the co-op, that's more of a creature of statute. The HOA is really governed in the election process mostly by the governing documents. And so if in an HOA setting, if you're not running it like the condominium, and as Jeff just mentioned, there are some of our clients, HOA clients, who've adopted condominium-like elections where you don't need to have a quorum to have an election. But in an HOA setup, if you don't establish quorum, then you don't have a meeting. And then whether you then whether the board rolls or whether there's an issue with candidates being seated, I think that's a technicality, an issue that we're going to discuss a little later. But in an HOA setting, if there is no quorum, there is no official meeting. And so you go home.
So just so I understand then, so in a condo, you don't have to have the annual meeting to have a valid election.
You don't have to have an official annual meeting to have a valid election, correct?
Okay, and you need 20% for a condo of ballots cast?
20% of the eligible voters, and because if people have properly had their voting rights suspended, for example, their votes wouldn't count toward that 20%.
Okay, so we're at the meeting. It's valid. It's a valid meeting. Is there any? Tell us about any particular recommendations you have or pitfalls you have that we should avoid at the meeting itself. Jeff, maybe you could start.
Sure. Don't provide opportunity to turn the annual meeting into a bitch session. Stick to the agenda. If you have contested items, then have a meeting. Nothing says you can't have meetings other than the annual meeting. You can have special meetings of board meetings and membership meetings. Let's deal with all of those issues that the owners might be have issue with so that we can have a smooth annual meeting. Follow the agenda. Remember that it's not a board meeting. So many associations, we sometimes, Michael and I will walk into these meetings and there the board is sitting up front and they're about to open a board meeting. Well, no, you have to remind them this is an annual meeting. And then like Michael suggested, either the president or we will be requested to run the meeting. And finally, if you haven't adopted rules and regulations governing member participation at annual meetings, you should absolutely talk to your attorney about getting those drafted and getting them adopted by the board at a properly noticed board meeting. Mike, do you have anything to add there?
Yeah.
No, I think that's, there's other pitfalls, but I think you want to discuss the other pitfalls as we get into further sections, like actually pitfalls during the election itself. Yeah. So the only thing I'd talk about that I would add there is just to be very cognizant of your meeting notice requirements and follow them. Like Jeff, the condo one, as Jeff pointed out, easy 60, 40, 35, and then the second notice 14 to 34. HOA is very much governed by your governing, you're going to look to your bylaws, and if they're silent, you're going to go with the 14 days. But the HOAs, they have nominating committees and other things like that you see. So if you have that in your documents, then communicate with your attorney, clarify that you're running the process correctly. And if you don't like the process, then amend your documents.
Here.
When you talked about adopting rules and regulations for conducting the meeting, does that talk about who can speak, how long a resident can speak on an issue? Is it different for condos or HOAs? Are those types of things what you incorporate there? Or are those rights given in the statute?
I think that's what you're talking about, right, Jeff?
Yes.
Yeah, rules governing conduct, and quite frankly, by the way, those listening, rules governing conduct should apply to board meetings, committee meetings, as well as member meetings.
Absolutely, good point, Michael.
Yep. Okay. Annual meeting we've talked about. We've kind of gone through a bunch of stuff there. Let's get to the election. I want to run because I want to be a board member and have all the power and prestige that comes with being a board member. Who exactly is eligible to run, and is there any distinction between condos and HOAs?
There is. Oh, Mike, you want to take it or want me?
No, you go. You go. But there are some co-ops on the line. We don't want to feel like we're ignoring them. So
I'll do HOA condo. You can swing back to co-op.
Condo and co-op are the same. So do that.
I was just trying to give you, defer to you on that.
I'm good. I'm good.
Right. So who's eligible to run? Generally speaking, it's really interesting. Florida law does not require a board member or an officer, for that matter, to be a member of the association. If you want your board members and officers to be restricted to only members of the association, you need to amend that into your governing documents. So let's start with that. I think, Craig, you and I were talking about an odd situation where a disgruntled tenant could actually try to run for the board, but could be prohibited from attending an annual meeting because they're not actually a member. So some interesting things there. If you're going to run, there are some, who's eligible. So you want to be a candidate. Well, you have to be eligible at the last very moment when you declare your candidacy. So for an HOA, if you're delinquent in any monetary obligation, you're out of there. You are not qualified to run. For a condo, if you are delinquent, not in a monetary obligation, but just the assessment obligation. That was changed by the legislature because it was thought that some condo associations were creating mythical fines to keep people from running. So therefore, they restricted the legislation there to assessment obligations only. And then for both of them, this is still on the books, if you are a felon and your rights haven't been restored for at least 5 years, you're not eligible to run. And if the DBPR, because you've had some bad conduct in the past and they've proclaimed you are not eligible to run, you are not eligible to run. So Mike, anything to add there?
Well, yes. One, I want to point out those things that Jeff mentioned that's it, guys. That's when you're not eligible to have your name put on the ballot. So the questions we get often, they're suing the association. They have violations that, documented violations. Those things do not preclude a candidate from running. It might preclude them from getting elected, but that's politics and that's internal in the community. But it does not preclude them from having their name put on the ballot if they otherwise meet those eligibility requirements that Jeff just went through.
Good point.
Monetary obligation, so that I make sure I understand: a fine, a late fee, you
name it. You owe money to the association.
You didn't maybe charge anything.
Well, here, Craig, here's what happened. Like, you ran into the gate and you damaged the gate. It was $250 to repair. You still haven't reimbursed the association for that. You're not eligible to be on the HOA ballot. And as Jeff was pointing out, the last date you're eligible. The condo world is a cutoff of 40. So on that 40th day before the election, that's when you're looking to see, is there any assessment obligation that this candidate owes? If there is, then unfortunately, as per the law, is cut and dry. There's no discretion that the manager has, that the board members have, that your legal counsel has. That's what the law provides.
Right.
Okay. And so at the 40th day, if you are delinquent in any assessment in any amount, $1, technically you are ineligible to have your name on the ballot. HOA, the awkwardness of that, right, Jeff, we talked about this yesterday, is many HOAs take nominations from the floor. And so if you're nominating yourself and then you putting the board, the manager, maybe the attorney, if they're there in the awkward position of having to say, maybe go over, whisper to you, no, you can't run because you have a balance. So it behooves you as a candidate to know your financial obligations. Whether you agree with them or not, be aware of them in advance of the meeting. That is your obligation. That is not on anyone else.
Completely agree. And Michael, tell us about you explained the other day a very unique circumstance, which I think could catch people off guard. So can you walk us through that particular?
Sure. And I got to tell you, I don't know how unique it is anymore, but I think it's the situation. I agree with you, is something that people might not be as aware of, though. So hypothetical, because we're not going to speak about any particular community, hypothetical condominium association puts out their 60-day notice, and the 40-day cutoff is the 5th of the month. And where they pay they pay their assessments monthly. So the cutoff is the 5th of the month. On the 5th of the month, 10 candidates had submitted a notice of intent to run, but half of the candidates had a delinquent balance as of January 5th because they hadn't paid their January 1 assessments, or February 1, whatever month it was. So we'll just use January for easy. So they hadn't paid their January 1st assessments. So the law was changed a couple of years back, and 718.112.2D contains the following. This is where it talks about those eligibility requirements Jeff mentioned earlier, and one of them being that if you're delinquent in the payment of any assessment due to the association, you're not eligible to be a candidate. And it says, for purposes of this paragraph, a person is delinquent if a payment is not made by the due date as specifically identified in the declaration of condominium bylaws or articles. And if a due date's not specifically identified in the governing documents, the due date is the first day of the assessment period. In this scenario, the governing documents said that the assessments were due on the 1st of the month. They were late after 10 days. The statute though says if it's going to be you're delinquent if you don't pay by the due date, not by the grace period date, by the due date. So unfortunately, in this situation, in my opinion, in my hypothetical, my opinion is the five candidates who had a delinquent balance on the 5th of that month were not eligible to have their names put on the ballot. It's not, I'm not happy about it. Nobody's happy about it. I don't know. Maybe some people there are happy about it, but I mean, as counsel, that's the point. Also, we don't quote have a dog in the fight, so to speak. We're asked to provide legal opinion, and you look at the statute as it's been amended, and it seems pretty clear to me. I think it's pretty clear to us that is the holding there. So yeah, it was a little bit of a unique situation because you had these owners they were current on December 31st. But as of January 1st, they were owed assessment. They had an assessment due. Half of them paid it by the 5th. The other half didn't.
All right, Michael, question for you on that, just exploring it. We know in an HOA, you are delinquent in your monetary obligation, and the last day to declare your candidacy, well, then you're not running, and you have up until that last moment in time to declare and get your monies satisfied with the association. But at the condo, a little bit different. It's really not the last day to declare your candidacy. So if the 40-day, you had to let the condo know by the middle of January that you were going to run, because that was day 40, but you were delinquent in the payment of your January assessment obligation, even though you may be paid it on the 14th of the month, the fact that it was due on the 1st of the month, strictly applying that statute means you're not eligible to run, because even though you're now current, you have that delinquency.
No, the distinction though is I hear what you're saying, but the distinction I see it is the statute says on the last day what is your balance on the notice of intent due date. So if the notice of intent due date's January 20th, the fact that you paid late, now I'll throw a wrinkle back at you, not for you to answer because we're not going to, but you paid late, so you actually owed a late fee. You didn't pay the late fee. You paid your assessment. Are you still eligible to run? Well, they changed the statute to say assessment. I don't believe late fee is the same as assessment. So I would advise in that scenario that they still owe that late fee, but they are eligible to run as long as they've covered their assessment balance. Although then you have the flip side of application of payments. Right. So we could go down the bottom line. The bottom line is this. This is the bottom line, guys. I want to say it again, Craig, that you're right. We're going down a rabbit hole. If you want to run for the board, then, and in a condo you want to run, then don't wait until day 40 to put your notice of intent. Make sure it's your obligation to get it there. There is a hard and fast cutoff. It's a Saturday or Sunday or a holiday that doesn't extend the date. So if you want to run, you get that 60-day notice. Well, turn that candidate form around and you can email that. You don't have to mail it back. You can scan it and email it back immediately. Don't wait till day 40. And also make sure that you contact the management office or whomever's controlling the documents and get in writing that your balance is current as of that day so that you don't have an issue. And if it's not, it's your obligation to make sure you get that payment in. And handing somebody a check on day 40 that hasn't cleared yet may not cover it. So don't wait. If you want to run for the board, and that's encouraged, then make sure you take care of these things in advance. And in an HOA setting, know your cutoff date. If it's the date of the annual meeting, same thing. That's my advice, Craig.
Good.
Okay, so I'm going to play everyman in this one, not the attorney. So a couple of quick questions, especially for condos. Is a special assessment included as an assessment? So if you have an unpaid special assessment, that also triggers you can't run. You're not eligible. Is that fair?
Fair.
If your annual meeting is on the 1st of the month of that month, I guess it's when you declare you're eligible, right? So really you have to be current. So really the timing of the meeting doesn't matter.
Right.
From the context of
in your example, if for some reason your notice of intent was due on January 1st, then I think you'd be okay. Because that's the day they're checking.
Yeah. Okay.
Hey, one thing you might want to do as well, a smart practice would be on the day that your notice of candidacies are due, so 40 days prior to the election. If someone turns it in at 11:59 p.m., that technically would be on the 40th day. So if you're going to have a cutoff, right, as they need to receive them by 5 p.m. on that day, on the 40th day, you need to notice that in advance. And if you don't put that time in there,
Right.
and then really it should be the end of business, what have you, then that could be problematic as well.
Okay. And then there's a bunch of questions coming in on, just on eligibility. So if I can maybe summarize from a condo standpoint, let me put this in kind of every man's words, and you can tell me if I'm right. From a condo standpoint, if you're delinquent in the payment of an assessment, you're ineligible. If you have a violation, you're fine. If you're suing the association, you're fine. If you have a dispute over an ARC, you're fine. All of those types of things are fine.
Yep.
Similarly on an HOA, the only thing that changes is monetary obligation. Everything else, if you have a violation, you're fine. You're suing the association, et cetera, et cetera.
Correct.
Yes.
Good stuff. Okay, let's move on. And I love your advice, Michael. You're responsible as a candidate to verify that you're eligible.
Yeah.
And so
Yeah, I sort of jumped ahead and answered that section already for us.
Yeah.
Every now and then we hear, from the owner that, hey, the association didn't send me my coupon book. Really? You live in an association. Hello. Not getting a coupon book is no reason not to pay your assessment.
Fair.
Craig, the one thing that I saw that you had talked about with us that we didn't mention is, can non-owners run, as far as eligibility?
That's right where I am now. So can non-owners run? And I think the answer was from Jeff was yes, but is that
Document specific?
Document specific?
And if the document
There's nothing, right. Nothing in the law that prohibits a non-owner from running, but many community association documents do. And many communities have amended their documents because they weren't drafted that way initially. But you do need to look at your governing documents, deck articles, and bylaws to determine if a non-owner can run.
Okay, good. Okay, so now I want to run, and I'm eligible to run, and I want to communicate to the residents. Talk to me, Michael, about the intent to run forms and getting them in, and then the letters, the document to introduce myself as a resident. And Jeff, I'm going to get you to talk about HOAs, but Michael, if you could
on the condo side?
condos.
Sure. Oh, I won't repeat what I talked about the intent to run forms and making sure you have it in timely. So that I've already addressed. So that has to be the cutoff is 40 days prior to the election. And that date should be accurately provided in the first notice, by the way. And then it also will say that you have, if you want to submit an information sheet on your candidacy, like why people should vote for you, you have an additional 5 days or up to 35 days prior to the date of the election to submit that. It is a 1-page, one-side, 8.5 by 11 sheet that you can write. Well, the objective is for you to write why people should elect you. Unfortunately, often you'll see people write why you shouldn't elect somebody else. But and Jeff, I don't know if you have a different, I don't believe you have a difference of opinion here, but we get asked all the time, hey, this candidate is just basically bashing the board. And we tell them, you don't have editing rights. That form, you can certainly respond. You can respond in your own, on your own, to misinformation or allegations. That's part of politicking, but you do not have the ability to edit a particular letter. Now, I will caution, if you are putting something in your candidate information sheet which could expose you to legal action, if you are libeling, defaming, if there's libel in there, then you need to be cautious of that. But the association can't edit it.
And you're going to laugh at this question, but we get it. What about font size? Is it as much as I could get on a page, or?
Yep.
So I'm okay. Okay.
Yep.
1 page. That's the bottom line. 1 page.
1 page, one-sided.
1 page, one-sided.
Don't flip it over.
Black and white.
8.5 by 11. I don't think color matters.
Okay.
Well, if you turn it in color, we're going to print it in black and white. It really doesn't matter.
Yeah.
Right.
Okay. Jeff, anything different? Because this is anything different in HOA. Let me ask you that question.
Welcome to the wild, wild west, the candidate information sheet, the candidate information night, right? So many HOA documents don't provide any guidance whatsoever regarding this particular subject. Many associations on their own include in their requirements, hey, if your name's going to be pre-printed on the ballot and you want us to send out a candidate information sheet, then do so by this date. You got to create a fair playing field if you put that into effect.
Right. Okay. Good. So I want to ask a question. We're going to talk about candidates nights for a second. And Nez, can you pull question number 2? Does your association have a candidates night? What it means is an opportunity for the candidates who are running to introduce themselves to the community in a in-person or Zoom format. So let's see what is going on out there. Guys, what are your vote for or against candidate nights?
I go 4, and I
Good.
like them held informally. So it's not an official association meeting. It's more of a gathering where, the rules are in place ahead of time. We're going to have this informal gathering, March 5th, 7 o'clock at the clubhouse. If anybody wants to meet the candidates, each candidate will get 8 minutes to make a presentation about why you should vote for them. And you can ask questions after, something like that. Mike, what do you think?
Moderator, who would you have a moderator?
Usually it's either somebody not running for the board. Typically, I would suggest to be the moderator.
Right.
We've been asked to have attorneys attend and moderate.
And those you can do those by Zoom all the way, right?
Yeah.
Because we're not talking about an official meeting of any kind.
Correct. And you can, and again, I put myself in a position, if I'm an owner and I'm not really know the candidates, sure, and I'm interested in attending to hear that would be great. But yeah, I think that the idea is, if you're doing a candidates night, is try to establish reasonable guidelines that are uniformly applied, and keep it that way, and enforce it that way.
Guys, we get asked to moderate candidate nights. Are we okay in that regard? We also get asked to chair meetings. Are we okay to chair an annual meeting as a manager?
If you're comfortable, as long as you're not answering any legal questions.
Yeah, no, we never do that.
But you'll get asked them all the time.
We will, and we always, yes, we're very careful because we know you guys. But that's okay. That's good. That is good news. Let's take that off the table. We had an interesting situation. One of the questions,
Did we get the results of the poll?
No, I'm not there yet.
Oh, I'm sorry.
I had one more question, which was, can a board member advocate for particular owners running for the board? Michael, thoughts?
So here's the interesting thing now, and Jeff, I'd like you to chime in if you'd like. The HOAs are not generally overseen by the DBPR, the division, but the division does have jurisdiction over elections of an HOA, and so there is some. To me, there's some question as to, like the Florida Administrative Code, which offers a lot of specific guidelines to condos and co-ops with regard to this. Do those also need to be important? Do those then get followed for HOA elections? I think best practice. You talk about best practices. I think that's how I counsel. I think it just makes sense. And the key here is when you are sending out election notices in a condo, first and a second notice. Some HOAs will do a first and second notice. However, within those, the board members should not be politicking. There should be nothing other than, here's the information, make your decisions. If individuals on their own want to, hey, like you mentioned here, social media, want to go on their social media account and say, hey, vote for these people for these reasons. Well, there's nothing that precludes that. I don't necessarily think I'm not a big fan of social media getting it, interacting the association social media, because it can go very sideways very quickly. But yes, and you can send out letters, like, a board can send out a state of their year, like, hey, here's a summary of the prior year, and we hope to be able to continue this year. That's totally acceptable, but they just can't include anything in election materials.
Okay, good. So Nez, can you post the result? Oh, sorry.
And before you do that, well, there's the results. Interesting as we all look at them together.
Not very many. I guess a fair number. By the way, who decides whether you can have a candidate's night or not? The board?
Typically, well, some documents require it.
Right.
Those that are silent, it would really be whether or not the opportunity is going to be presented by the board. I also wanted to go back and address what Michael was talking about, whether a board member can advocate. You should stay away from advocating in your official capacity as a board member and do it only as an owner. You should not be using association funds to campaign. That would be an improper association expense. Nothing says the board can't send around a communication about how wonderful we are and all the projects we got done this year. But you should not be using the bully pulpit, so to speak, to advocate for particular candidates. I think that would be going too far.
Okay, I agree. That's basically, I think we are on the same page.
Good. Meredith, can you take that down?
I did want to say, Craig, the 13 people who don't know if you have a candidate tonight, please find out.
Yeah. Fair. Okay, Marinez, can you pull up? We're going to run through a couple of election scenarios because we got a lot of questions around what happens if this happens and the voting and all those types of things. So we want to take you through a couple of options. And Michael, I'm going to ask you to talk about condos and co-ops and Jeff HOAs. So let's start with,
Craig, can I also, before you jump into that, because I know this question will be asked, hey, who controls the candidate night? Just be aware. I mean, typically, if there's a bunch of candidates, like owners, and they want a candidate night, and the board, for whatever reason, the board's saying, well, we don't want to do it, do keep in mind, they're owners. They can just say, hey, we're going to have a meeting in the clubhouse and we're going to invite people to come listen, and you can come there, be there or not. I mean, I've seen it happen. So just, it's kind of like Jeff pointed out, it's informal. And whether it's with with seated board members who are running again or without, it can happen.
Okay, fair enough. Okay, so we're going to go through 3 cases, and Michael, I want you to walk us through kind of what happened. So we have a condo or co-op. In case number 1, we have 6 candidates and 5 open seats.
Okay.
We have an election, correct?
Yes.
Okay, and which means that we have at least 20%. We either have we have 20% of eligible voters casting votes.
Correct.
Condo crop. Okay. So now, second case, we have 5 candidates and 5 open seats. What happens?
There is the second notice will then go out, and it will not, instead of saying, appointment of inspectors of election, it will be modified to indicate that the board will be seated, and it'll let the membership know that we have the same number or candidates, in this case, same number of candidates as there were open seats. Therefore, in accordance with the statute, no need for an election. The board will be seated that night. And if there's other business, especially if you have amendments or something you want the membership involved, you'll push that, make sure you show up. But the second notice would be revised to just say we're just seating the board and there would not be an election. If there is no quorum, then you'd open the meeting, no quorum, no election, seating the board, close meeting, go to your organizational.
Mike, I don't want to confuse the listeners. You said no quorum, and I think you meant that 20% of the eligible voters didn't cast a ballot.
No. We're in a 5 candidates, 5 seats. I meant no quorum.
Very good.
Yeah, no. I'm saying if there's no quorum, since there's no election, it's pretty much an open and closed, quote unquote, annual meeting, and you go right to your organization, seat the board, go to your organizational.
Fantastic. Okay, and then the situation 3 is you have 4 candidates, 5 open seats. Take us through the impact of that, and then I want you to comment on how we fill the open seat. Okay.
The exact same explanation I gave for the 5 and 5 would occur here, because you have, in this case, less candidates than open seats. So that would be the only modification. And the second notice would inform there is no need for an election. We have less candidates than open seats. The following members will be seated. And then the organizational meeting, and remember, we talked about a recommendation that at the end of the annual meeting agenda, it would say immediate adjourn, and then it would indicate immediately following the conclusion of the annual meeting, the board will hold its organizational meeting, and it would have an agenda, because in a condo and co-op, you list the agenda, and the agenda usually is established quorum of the board, and then you would say, to elect officers. In this case, there could be an item that's added before elect officers to fill board vacancy. And then you could go to elect officers. I will say, when you have the same number of candidates, when there is no election, you know who the board's going to be. 4 candidates for 5 seats. I would speak to those four individuals and indicate, do you want to do this at the organizational? There's no obligation that they fill the vacancy at the organizational. The board has the discretion, unless the documents provide otherwise. There's no time frame on when you have to fill that vacancy. Obviously, you prefer not to sit with an even number board. Hopefully everybody's on the same page anyway, but you don't want to sit. So filling that board vacancy, if it's on the agenda for the organizational, you do it then. If it's not, they can do it. They can 48-hour posted notice. Single agenda item could be fill board vacancy, quite frankly.
Right. So really then, Craig, where you've put no second notice required, I think what you mean is there's no second notice of the election required, but you're still going to have to send out the annual meeting notice.
Yeah, fair enough.
So you are putting out that second notice still, the 14-day mark.
And then, Michael, one more question to this: 6 candidates, 5 open seats, less than 20% of ballots cast. Does the existing board roll?
Yes.
So no election. So
there's no official meeting. There's no election, and that's what you're announcing. And I will say that in that scenario, it's, in my opinion, the discretion of the rolled over board as to whether they want to try again before the next year. because they have attempted to hold that annual meeting. They properly noticed, put it out, and I have had that. I've been to elections, annual meeting elections where they did not obtain 20%. And these were not huge communities either. And so they, you needed maybe 20 people to vote and they didn't get it. So yeah, but there would be no election board roles, and then discretion with that board as to whether they want to try to do it again that sometime later that year, or just they stay on the board until the next year.
Mike, it's almost like a left-handed compliment. We didn't get 20% of the eligible voters to vote because people are generally happy.
Right.
Doing the good job you're doing.
Yeah. The only thing, Craig, that I will point out is if you have a situation where you're like a staggered board, or you're creating a staggered board and you don't have an election, so you can't determine who had the most number of votes to take certain terms, then you would, as a board, you could volunteer. I'll take 1 year, you take 2, or I'll take the 2 and you take 1, or you could pick names from a hat or flip a coin, however you want to do it. But you should resolve that. And it should be something that you put in your organizational meeting minutes so that there's a record of who holds what terms.
Yeah. And guys, I think it's interesting, and I think you purposely overcomplicate it so you can get invited to the meetings, but that's an aside. It is a good reason, because if you're going to have these things that come up at your meetings, you do want your attorney in the room so you can resolve them then. But anyway, that's I say that facetiously. Jeff, can you take us through the homeowner options here?
Oh, I can, and I surely wish it were as streamlined and straightforward as what happens in the condominium scenario, because we had some new legislation that came out a couple of years ago, 72306. An election is not required unless more candidates are nominated than vacancies exist. If the election is not required because there are either an equal number or fewer qualified candidates than the vacancies exist, and if nominations from the floor are not required and write-in nominations are not permitted, then those qualified candidates will commence service. So instead of there's no board rollover, those qualified candidates will then begin service. So really what we need to look at are 2 scenarios. One scenario has 2 outcomes, and the second scenario only has 1 outcome. So let's do the easy one first. We have 5 seats. I'm going to just I'm not sure which case numbers I'm doing, Craig, but we have 5 seats and 4 people running. At this HOA, there's no nominations from the floor permitted, or no write-in candidates are permitted. Well, we don't really need a quorum then. We don't care about the quorum for this particular outcome, because without regard, those candidates are then sat as the new board. So that one's easy. When there's no nominations, no write-in candidates, you got 5 seats, 4 people running, then those candidates are going to be seated. But what happens if we have 5 seats, 4 people are running, but here in this scenario, either nominations from the floor are permitted or write-in nominations are permitted? Well, we get 2 different outcomes. One if we have quorum, one if there's no quorum. If we have a quorum, the new board is sat from the candidates who put their name in. But if there is no quorum, then the existing board is going to roll over. So it's very confusing. I have to go back to this legislation every time and read it extremely carefully and create almost a matrix for those HOAs where they do have the nominations from the floor and those who don't, to be prepared in advance for what that outcome might be. So you're going to need, if you're at the HOA, then you're probably going to need to consult with your attorney on those outcomes. And it is a little confusing, and we can thank the legislature for that.
Right. Because I think actually it is. And I think if I could believe, Jeff, if there is no nominations from the floor, that's when you would seat those candidates who are nominated in advance. But if you have nominations from the floor, that's when, if you have quorum, it has to roll, because you don't have the opportunity to take the nominations from the floor. Correct?
We're running short on time here. We have 4
Okay,
minutes.
we
We can go down this rabbit hole.
Yeah, I think we proved that the point being that it is a confusing piece of legislation. And the best thing we'd recommend is, if you really want elections in an HOA, amend them to be like a condo.
Exactly. Okay, let's take down.
Yes, I can't tell you how many times we have done that, where we say, if an HOA governing document in elections, no quorum is required, only 20% of the eligible voters need to cast a ballot, there are no nominations from the floor, etc., and it makes for such an easy election at the HOA.
Okay, let's move on, guys, to counting of votes. Michael, you're going to kind of rapid fire here to you. When do you close the balloting?
Well, you're talking in the condo world.
In a condo world, yeah.
And if you're running it like a condo, then official voting should be closed when you go to open that first outer envelope. So the first part of that meeting, you are verifying the signatures on the outer envelopes to determine whether these are additional eligible votes that you're going to count. During that process, anybody who wants to vote, they should be permitted. But as soon as the inspectors say, hey, we're done verifying, I just did this yesterday morning, we do a motion to close voting, and that is confirmed in the minutes. And if there's no quote official meeting, it's just confirmed with the group, so that when that person comes running in 10 minutes later, the whole group there knows, hey, they're not allowed to vote.
I do it close, but slightly different when I'm at the annual meeting. And before we even start verification, I explain that issue to the membership. And I say, would someone please make a motion to close the balloting? So if someone comes in and we don't let them vote, you don't blame me. Seems like that's a really good point you made. You leave that window open until the outer verification of the envelopes is done. And I think I'm doing it a little bit earlier in the meeting. And I think either one is okay, as long as the members are making the choice so they don't come after us with pitchforks.
Yeah. Michael, what if I want to change my vote?
No.
You can stop there.
When you're talking about voting for a candidate, once you've submitted your ballot,
you're done.
Your ballot is done. You're done.
That's an exception, though, because absentee
hold on.
balloting,
Well, you can. Well, I will pass the baton, but I was saying is, so we're talking an easy one is the condo co-op or the HOA where you're submitting when you submit your ballot.
Good.
If you're able to vote by proxy, which you cannot do in a condo or co-op, but you could in an HOA, and you're voting by proxy, you could change your mind. But I think practically speaking, the proxy in an HOA is I give Jeff my proxy to vote. He goes in and he gets 2 votes. So unless I run in right away, wait, before you do that, I'm taking my proxy back, then I don't think that there's a situation on election, voting for the election, I mean.
The proxy holder could change their vote, though. I've got those 2 proxies, and at the last second, the candidate pissed me off, and I want to go change my vote, and the balloting isn't closed. Voting by proxy, I could still change my vote.
Right. Okay.
Interestingly enough.
Guys, let's talk about counting. Who should count? Who should count the votes, do we think?
Members not running for the board, not the
manager. Not running for the board, not related to anybody running for the board, not living with anybody running for the board. And I mean, it's simple, but we get the volunteer, we get the inspectors up front. I always say, can I get a list of the inspectors? I read them out. Anybody have any objection to any of these people? Yeah. Hearing none, hearing nobody, seeing nobody, confirm. Thank you, volunteers. Let's get going. To Jeff's point, that puts everybody on the same page. And I do think, and I think another point that is important is if you're running a meeting, and I know that Jeff and I and our team does this, Craig, any of your team does it. The easiest thing to do is up front, go through the entire process. That's the best practice. Go through the process. This is how this is going to run. Anybody have any questions? Anyone? And then you take them through the process up front, and everybody's on the same page.
Mike, I think that's great. That is great, guys. Going to ask you one more question on this, guys. What if there's a tie?
Looks like you're going to have a runoff, but maybe you can talk to those 2 folks that tied and see if one of them will agree to perhaps withdraw their name.
Right. And there is the condo co-op world has specific guidelines if there is a tie that you have to send out you send out an election ballot and candidate information sheets only for those who tied. I think it's sent out within 21 days of the election date. Don't quote me on that. Ties don't come up often. But if there was a question that said, hey, if there's a tie, do we have to wait till that's resolved to have the organizational? And the answer is not. Legally, you do not. That's a discretion. If there's 5 board members, 4 get elected, there's a tie for the 5th spot, and at least 3 of those 4 want to move forward with the organizational, you move forward with the organizational.
And I would just add to Michael's really good points there that you can always reorganize anytime you want to during the year. You can always reselect officers.
Okay.
Also good point.
One more, I guess, more of a what to look out for. Michael, what would you say is the number one reason that elections are contested?
Well, I guess I laugh only because they're validly contested for, I'll say. I think I don't know if it's the number one reason they're contested. I think that the most important issue that I see come up is if there's allegations of ballot tampering, and let's be clear, that sounds a lot more nefarious than it is, because the law is clear. And I talk primarily when you're talking the condo co-op setting, because HOAs, people are generally, if they're voting there, they're handling in a ballot. But in the condo co-op setting where they're the ballots in advance, do not open them until you have actually at the meeting. They need to all be verified. before they can even be opened, and then there's a process to follow. So it's opening ballots before you're allowed to do so. You shouldn't even be opening the ballot box, quite frankly, until the annual meeting, although there is language in the administrative code, again, if it applies, that if you have you can verify these outer envelopes the same day of the meeting, so long as you have appoint that in committee, the inspection committee, and then 48 hours in advance at least, you post notice of this committee meeting that they're going to be at this place at this time verifying outer envelopes. I have, these large communities we represent, 500 homes, 600 units, they'll get 200-300 ballots. I love that. 3 o'clock, they're going to have this committee meeting, and from 3 to 5 or 3 to 6, they verify all these envelopes. I show up for the meeting then, and we have one of our attorneys who will oversee that to assist with questions. And then I show up at the meeting at 7, and we can be done in an hour because most of that's the hard part, is the verifying. The
Yeah,
tally is a little
easier. Electronic voting and
Boom.
all of this to begin with.
Yes.
Yeah, well, I know I want to make, there were a lot of questions on electronic voting, and I just really wanted to summarize our last webinar, guys, where we talked to one of the vendors, Ben Zelkovich from Get Quorum, on e-voting. It's a board decision. It's a unit owner decision to participate if they want. The best practice here is, if you're going to do this, there's some very specific language you have to follow, get with your attorney, pick a vendor. I would say, though, there is a distinction. Electronic voting and voting by email are two different things. You cannot vote by email.
Good point.
By the way, you can find that, I'm sure, on the KBR website or at www.castlegroup.com under resources and webinars if you want to see that webinar on e-voting. We're running a little late. I do want to quickly touch on organizational meetings for those who are able to stick around. Jeff, we talked about the best timing right after the annual meeting is the best timing. Michael, can you just quickly run us through the process of conducting a meeting? So,
the organizational meeting. I mean, I'll tell you, I think the way I do it, and I let the now remember, it's a board meeting, so we're talking to the directors. Membership can observe, and they can attend and observe, but there's really not a lot to discuss. And I'll say to the board, I don't know if you guys have had an opportunity to discuss. If you're ready, if someone wants to make a motion, a slate, president, vice president, secretary, treasurer, and then someone seconds, and everybody's all good with that. That's quick and easy. If you're not sure about that, or you want to go position by position, then you can nominate yourself or nominate someone else. I don't need a second on that. I just need to know the person being nominated will accept it. If there's more than one nomination, we have an election for the office position. We move to the next one, and it's very simple. I know I'm speaking fast because I feel like I'm good 5 more minutes. If everybody else is listening wants 5 more minutes, we won't rush us through, but that's basically, I think, the process to run the organizational. And it can be, they're done very, very quickly.
Michael made a couple of good points. You don't need a second on a nomination, which I think is
right.
There's some confusion in that regard. 2, is there a particular order you go in, guys? Like president down, secretary up?
Typically you go president down, I think. But again, if they're unsure, go to another one.
We did have an interesting question. If the nominations start at president and they elect the president, he still gets to vote on the other nominations for the other officers, right? Yeah,
I don't know. I'll clear that up, Jeff. But you're not voting as the president. You're voting as a director. Okay, so let's get that right away, guys. Maybe that's a Robert's Rules thing, and Robert's Rules are guidelines, guys. They're not the Bible. So presidents don't vote; directors vote. So you are voting on any issue that comes before the board.
Correct.
And Jeff, Jeff, let me ask you this: if the association is looking for a treasurer, they don't have anybody who's interested on the current board, can we elect a non-director as the treasurer?
Sure. It's so absolutely you can. It's really funny because primarily in our community associations, the officers are comprised of the board members, and that's where the confusion comes from. Does the president vote? And I always ask people that in webinars, and then I'll go into, well, does the vice president, secretary, treasurer? And I'm like, no, none of them vote at the board meeting because they're voting in their board capacity.
You tricked them.
Quick question for everyone that's still out there. You'll get an A on the exam.
That's funny. Well, listen, guys.
I do want to just add a caveat. It's rare. Well, I shouldn't say it's rare. The documents often provide, and you have to look to your articles and bylaws, that the president and possibly the vice president do need to be directors. some rare instance, it'll require all officers to be directors. So just, you do need to look to your articles and bylaws. And if they don't require an officer to be a director, then I have several communities who will find that CPA who's not interested in voting, but they'll be happy to step in and handle the treasurer role.
Good stuff. Okay, guys. Well, that was a great, lots of questions today, lots of information. Thank you very much to our listeners. Thank you for participating. We had tons of questions. I hope we got to most of them. So I wanted to thank you.
Can I answer one more, Craig? Because people are popping in. What about the 8-term law?
I saw that. Yeah.
Yeah. And guys, just know, first of all, that is in the condo set world. It's nothing in the HOA, and it does not apply. It's not retroactive. It's prospective. It will not have any impact until 2026 if it's still in the law in 2026. So circle back with us in a webinar in a couple of years.
Good stuff. Okay, guys, thank you very much. As always, we will talk to you in a month or so. Michael, go and make sure we do the right thing up there in Tallahassee. And we appreciate all your help. So have a great day, everybody. Take care.
Thank you both. Thanks, Castle. Thanks, Marinez.
Bye-bye now.